Welcome to Mayor Brown's International Arbitration Across the Pond podcast. Each episode is designed to provide insight on legal issues and other matters affecting international arbitration in the UK, US and around the world. The podcast is presented by two of Mayor Brown's international arbitration partners, Kwadwo Sarkodie from the firm's London office and Charles Harris from the firm's Chicago office. You can subscribe to this podcast on all major podcasting platforms, as well as Mayor Brown's YouTube channel. We hope you enjoy the podcast.
Welcome, Kwadwo. We're back again. What episode is this? We should have looked at that before we started. I don't know what episode this is. But look,
but I think we've been doing it for something like 2 years now. I think it was around summer 2020 recorded our first one. So we've been doing this for a while, and it's been a lot of good episodes.
16th episode. So now we're getting up there in numbers.
Good to hear.
So good to see you back. And it's funny that we're talking about how long we've been doing this, because we're actually here to talk about a topic that we have addressed, I think, at least a few times in prior episodes, right?
That's right. 1782 applications.
So you want to lead us in? And by the way, let me just say, I have thought last night and this morning about a good title for this episode, but I haven't come up with one. So we're gonna hold the folks in suspense till we actually put this one out.
Excellent. I always like to wait to hear what you come up with, Chucky. There've been some great titles down the episodes, and I'm sure you won't let us down this time.
Right.
But to lead off then, what we're talking about now is Title 28 of the United States Code, Section 1782, what we will call in this episode 1782. And we've talked about these applications, how they relate to international arbitrations, as you mentioned, Chucky, a couple of times in the past on this podcast. And what we have in recent weeks and months is some additional guidance by way of a Supreme Court judgment from the US. So, Chucky, are you able to summarize the position and perhaps what the Supreme Court judgment tells us?
Yes, and so the decision and the case is ZF Automotive versus Luxshare. And so what this case has decided was the issue about 1782. And as we've talked about in prior episodes, the question was whether Section 1782 permitted kind of wide-ranging document discovery and also testimony for use in a foreign international proceeding. And well, I should say for use in a private arbitration. And the key language in Section 1782 is what constitutes a foreign or international tribunal. So that's the key language. And that is the exact question that the Supreme Court was answering in ZF Auto. And ultimately, what the court decided was a foreign or international tribunal only included some type of tribunal that was endowed with some type of government authority, as opposed to a private international arbitration. So a little more about that. There were actually two cases at issue in ZF Auto. So the ZF Auto case, in that instance, the arbitration was just a private arbitration. In the other in Germany, and the second case, the arbitration was actually an ad hoc arbitration under UNCITRAL rules between two foreign nations, between Lithuania, between Russia. And in both cases, the Supreme Court found that those particular arbitrations were private arbitrations, and they weren't foreign or international tribunals such that they would allow discovery under Section 1782.
Thanks a lot, Chucky. That's a really helpful background. So I remember when we discussed this last time, we talked about a previous Supreme Court judgment in the Intl case. How did the facts which were considered in Intl and the conclusions which were reached there, obviously as interpreted in subsequent US Court of Appeal judgments, differ here? Was Intl overruled? Was it distinguished, or was it simply so different on the facts that it didn't actually bear detailed consideration?
Well, actually, the import of Intl is still good law, and it's still relevant. So what Intl gave us was it gave us the factors. So of course, the first issue that the court has to answer, and the court answered in ZF Auto, is discovery allowed for the particular proceeding that is at issue? And in that case, it was a private arbitration, and it was ad hoc arbitration. Now, if like say the court would have said, okay, those proceedings are foreign or international tribunals, and we're allowed to give discovery under Section 1782 for those proceedings, then the court would have looked to the Intl factors, what we call the Intl factors. So do these, and I don't have the factors at hand right now, but do these factors justify the amount of information, the testimony, whatever the interested party is requesting from the court? So the Intl factors, those things are still in play to the extent that the court is allowing discovery and information for foreign and international tribunal. So yes, Intl is still in play.
Excellent. Thank you very much. So for parties to international arbitrations, anywhere in the world really, including the US, is 1782 something that they now need to have less concern about? Consider maybe less so as a potential option to either seek information or documents, or is it still relevant?
So it's definitely still relevant. I think that there's a couple of things I would say. I mean, one of the things that people need to consider is, look, one of the arbitrations I mentioned, which is the ZF Auto arbitration, one of the arbitrations at issue in the ZF Auto case, was a private arbitration. But ZF Auto was not a third party. ZF Auto was actually a first party. So one of the things that you should consider, and I'm going to get, this doesn't answer your question exactly, but I'm going to get to that question. One of the things that parties should consider is, look, now that you have 1782, and when you're dealing with the party in the US, maybe you should have some language in your arbitration agreement that allows for discovery of that first party. So there's a drafting exercise and changes you can make in drafting that address the decision here in ZF Auto. And I should also say that for that arbitration, it was actually pre-dispute arbitration that Luxshare, the other party, was seeking. So you can address that issue through drafting. As far as relevancy, another issue is, so the other dispute that was at issue in ZF Auto, the one between Lithuania and Russia, that was related to an international treaty. So there were a number of different options that the parties had under the international treaty to resolve the dispute. And so happened they chose the ad hoc arbitration under UNCITRAL. But they could have chosen other options that would have given them a lot stronger argument that, hey, the proceeding that is deciding this dispute is a proceeding that's endowed, somehow cloaked with some type of governmental authority. So it matters. It does still matter. And where I'm getting at is that it can dictate the question of what information you need in the arbitration can dictate kind of the procedures that you choose in order to resolve the dispute. And it can also dictate the language in your arbitration agreement. So I think it does still matter.
Thanks. No, that really helps in clarifying it. So essentially to understand that certainly where either a treaty dispute is involved or one of the disputing parties is a sovereign state, and we're not talking about a straightforward contractual commercial arbitration, there may still be considerations and factors to consider as to whether 1782 might apply.
Absolutely, absolutely. Because I mean, one of the things that the Supreme Court made clear is that, look, there's not a bright line rule about what kind of proceeding is considered a foreign or international proceeding. There's certainly some proceedings that no, there's going to be more difficulty, particularly just a private commercial proceeding, in arguing that it falls under 1782. But there are certain proceedings. There's these treaty disputes, and there's a little bit of gray area there, and some arguments that can be made.
Thanks a lot, Chucky. So moving on to some of the implications then of this decision and the landscape which will now apply, and particularly now I'm thinking about commercial arbitrations, international commercial arbitrations under private contracts. I think we as a US lawyer and a UK practicing lawyer may have a slightly different perspectives, and we perhaps butted heads on these sort of issues sometimes in the past. But my view certainly is many parties to international arbitration will actually come into international arbitration expecting a narrow scope for document production and examination. And indeed, I feel that's very often why parties will choose international arbitration as opposed to domestic courts. They're used to using things like the IBA rules of evidence, Redfern schedules, carefully particularized and specified requests which are made that the other party has the opportunity to comment on before a tribunal will make a careful and reasoned decision as to the scope of discovery. Now, what I've certainly seen from in the past and how 1782 applications are sometimes used is the other end of the scale, probably what perhaps be more familiar in the US courts, but a broader range of document production. And I'd certainly be concerned that some parties looking at that would consider that quite onerous. And so is it your view, looking at it from the US side, that there is a difference? And how do you see that difference playing out now that the decision has been issued in the ZF Auto case?
Well, I think there is certainly a difference in philosophy and what we call discovery and what you might call document exchange across the pond. So, but at the same time, I mean, when you're talking about the intel factors, that's where the intel factors come in. I think you can, to the extent that you do have a foreign or international tribunal such that discovery is allowed under 1782, I think certainly an argument you can make is that, look, discovery in this instance should be more circumscribed because that's what parties are used to in ultimately in the tribunal at issue. So I think that, yes, I mean, there's certainly differences in philosophy, but it doesn't, the use of 1782 doesn't mean that you have to have this type of wide ranging discovery or document exchange like you might typically see in a US court. And I'm not suggesting with my answer that there's anything wrong with that, by the way. That's to be clear.
Thank you, Chucky. But I think we made an important point earlier about how parties can actually address some of this in the drafting of the arbitration clause itself.
Yeah.
And I think that's an important point in consideration, and it can go both ways. What you might have a party at the outset of the contract who anticipates that in the event of arbitration they want to see broader document production and discovery. Equally, a party in a different position might wish to see that be made more narrow. And the fact is, it is open to the parties to negotiate and provide for that in the clause at the outset, if that's something they think of. And I certainly would advise parties to complex contracts likely to give rise to extensive and complex disputes being dealt with through arbitration to consider that and to provide, by way of the clause itself, certain guidance which the tribunal or a court considering this later on can take into account, and therefore ensure that what the parties get is the level of document production and the approach that they actually want and expect from the outset, and they don't get surprises.
Oh, absolutely. And maybe I should take this moment to make a plea to our transactional colleagues that there are a lot of different issues that we're dealing with, and that we understand as dispute lawyers are critical when we're drafting our arbitration agreements, particularly our international arbitration agreements. So this is yet these changes and how dynamic the law is across multiple jurisdictions is another reason to make sure that you're getting the professionals involved when we're drafting these arbitration clauses.
Absolutely, I could fully endorse that, and I'll just, repeat that to my transactional colleagues over on this side of the pond as well. Now, having set that out, what I'd like to do is have a bit of a look as well at the English law position, and perhaps now that the recourse potentially has been narrowed with regard to commercial arbitrations from a US perspective and from the US courts under 1782, the position with regard to whether the English courts or courts of other jurisdictions may become a little bit more relevant. So what I will do is try and share some of the perspective on the English courts, and we can also look briefly at some other jurisdictions as well. But before I go on to do that, Chucky, is there anything else either in relation to 1782 or indeed besides 1782 with regard to assistance that the US courts can provide that might be relevant in the context of international arbitration?
You know, one thing that I see like as still kind of a gray area is the question of what happens when. So let me back up and say it like this. What we've generally seen is that you have interested parties, and let me actually look at the language of statute to make sure I'm being precise here. But what you have is you have interested persons who are making applications to the court under 1782 for this information for the foreign proceedings. Now, what happens when you have, so that's one way that you can make an application, but you can also have an application through letters rogatory or request made by a foreign or international tribunal. So say the English court sends letters rogatory to a court in the US and says, hey, we need this information. So what happens when you have that extra step and have the foreign court involved in actually seeking that information, and that information is ultimately for the arbitration, the private arbitration? Does that somehow cloak the arbitration with some type of governmental authority, or does also the thing, the way you can look at it, having the foreign court involved in it in seeking information, does that somehow change the dynamic? I think that is one question that is still unclear under 1782, and how that is going to play out. I think is going to be kind of interesting.
Indeed. So that does sound interesting. I think we'll have to watch closely to see if that argument gets taken and how it gets decided.
Right. So that's the only thing I would say. I think everything else we have covered. And I mean, look, it's nice to have some resolution to this question that we've addressed a number of times after several years.
So speaking of things we've addressed before, what I'm going to look at now is an English case from a couple of years ago, which concerned the operation of Section 44 of the Arbitration Act 1996, which governs arbitration here in England, and also similarly addresses the question of how assistance can be granted by the court in support of the arbitration with regard to testimony of witnesses and provision of documents, how that might relate to third parties, and in what circumstances that will be made. So really, many of the similar questions that arise in the context of US applications to the court and US court support to arbitration with regard to 1782 that you've been setting out. And I'm just wondering now if, given the move by the the US courts to restrict the use of 1782 in relation to private commercial arbitrations, whether now it's worth revisiting this position under English law and see if that becomes a little bit more relevant with regard to the international landscape more generally. So what I want to do is just briefly outline the provision which is examined and looked at in the case, and that is section 44 and specifically subsection 2 of the 1996 Act, because that's what provides for the court to be granted essentially the same powers to grant interim measures in support of an arbitration as it does in relation to civil court proceedings. And so that includes taking evidence of witnesses by way of deposition and also seeking the production of certain documents. So yes, it provides the court with a discretionary power to assist the parties. Importantly, the procedure is that the application must be made with the permission of the tribunal, unless it's a case of extreme urgency, or by consent of both parties. So there's the opportunity both for the other party to object or to seek to limit the application, and also for the arbitral tribunal itself to give its view on what appropriate support might be. But the case in question, and as I mentioned, is a case that we have certainly touched on a few episodes, or probably many episodes ago. Like you say, we're on number 16 now. But that was the case of A and B and C, D, and E. It was an English Court of Appeal case. I'll refer to it as the A and B case for the purposes of this discussion. But that was a case where the court decided, well, the first instance, it decided, in fact, that section 42, subsection 2 was not broad enough to be made against a third party in relation to a New York seated arbitration. But when that was considered on appeal, that was reversed. And so an application in relation to the testimony of a witness who was based in the UK, was refusing to travel to New York, could be compelled by the UK court in support of a New York seated commercial arbitration. So that was a pretty significant move and expansion of the scope of the powers under section 44 subsection 2. There's been a fair amount of discussion in relation to that. I think broadly speaking, it has been welcomed, because if the scope of it was restricted really only to the two parties to the arbitration agreement themselves, that really would beg the question of what its use was, because at the end of the day, a witness could very likely be a party who is beyond either of the disputing entities themselves. And indeed, witnesses often with some of the most useful information and evidence that might shed light on the dispute may very well be third parties. And the fact also that it's available in support of an arbitration not only seated in England but also seated elsewhere in the world is a useful emphasis of the manner in which the English courts will work to support international arbitration more generally, and the efforts of parties wherever they might seek their arbitration to effectively resolve their disputes. But I think, just to I suppose make a few points of distinction with the regime under section 1782, which we were discussing earlier. I think the position under 44.2 is somewhat less permissive, and really touching on that point we made earlier about the scope of discovery from a US perspective, as opposed to perhaps what would be more common international arbitration practice in other jurisdictions. So the scope of the documents that might be sought is more restricted. The party making the application has to be very clear about what documents are sought, and so it's not necessarily a direct comparison with the powers under Section 1782, but nevertheless it is relevant. It is powerful because, as I say, it can be made in support of overseas seated arbitrations, and it can be made in respect of third parties.
Okay, well, it's interesting to learn about that, and like you said, we talked about it before. Is there anything? Do you see any? What are the practical implications of the A and B case? If you can talk about that a little bit.
Well, yeah, I mean, so what I'll just run you through is the outlines of the procedure for actually applying for one of these orders, and I think through that it'll serve to illustrate some of the differences with the 1782 approach, and I think the key differences are around the fact that the other party has to be notified. They get the application has to be made to them. It has to be similarly put before the arbitral tribunal and confirmed that the arbitral tribunal itself isn't able to assist. And all of those give the opportunity for either the other party or the tribunal to perhaps temper and push back on the precise scope of what's being sought. But the routine is it's an application's made by way of a claim form supported by a witness statement, which is submitted to the English court. And the purpose really of the witness statement is not only to explain the background, but to cover the specific issues in relation to which the evidence being sought in the application is being applied for, to identify the documents being sought with clarity and particularity, to explain the reasons why the court is being applied for, as applied to, I beg your pardon, as opposed to the application being made simply to the arbitral tribunal. So, that's the point I explained about tribunal has to have already considered it and explained why it can't provide the support being sought. And additionally, in relation to an overseas seated arbitration, the application should explain why it is that it's suitable for the English court to intervene, because again, the court will have to have regard to issues such as comity, as to respect for overseas courts. If, for instance, a court in the seat of the court where the arbitration is seated has already been seized of an application in relation to support, or they've already considered it and rejected it, I think that would be a relevant factor for the English court support. So they're all factors that have to be set out with clarity in the supporting witness statement. That's then submitted with a form of the draft order which is sought. That has to be served on the other party. It's also provided to the tribunal. So there's a great deal of transparency. It's a process which has to be set out, has to allow both the tribunal and the other party the opportunity to then consider that, and then they have the opportunity to comment before the English court, and then the English court, taking into account those factors and submissions on both sides, will make the order. So that's the overall sort of outline of the process. But I think the key thing to take away from that is that back and forth, and the fact that when the court makes that, it will have heard both the specifics of the documents being sought and the reasons for that, any objections, and then it will go ahead and make a decision accordingly.
So one thing we did look at, just as we, I think, kind of close this discussion out, is whether there are other statutes similar to the UK Arbitration Act of 1996 in other jurisdictions. And we did find some. Can you just talk about those really quickly?
Yeah, and I think our point of departure for that should be the anti-trial model law, because that obviously applies in a number of jurisdictions across the world, and is broadly recognised as providing as sort of a gold standard for the key matters to be addressed and provided by way of a functional and effective international arbitration law. And so in the UNCITRAL model law, that's addressed by way of Article 27. Now, that allows for a tribunal or for one of the parties, provided that the tribunal has approved. So that if one party objects but the other party seeks this support, then they have to get the tribunal on side and supporting them in relation to that. But it allows them to request a court in the jurisdiction which in which the UNCITRAL model law is in force, to provide assistance with regard to taking of evidence. So that is similar in its essence to what we discussed under Section 44 of the 1996 Act in England. It provides for the court to use its powers which will extend to compelling the giving evidence by witnesses, production of documents, preservation of documents, materials, and so on, but to do so in support of an arbitration. Now, that raises the next question, which is interesting, of whether that's solely limited to an arbitration which is seated in that jurisdiction, that is to say, the jurisdiction in which the UNCITRAL model law is in force, or whether, as was the case we described in the A and B case, it's possible for that to be applied in support of a foreign-seated arbitration. Now, that's going to, I think, be a question really for the courts in particular jurisdictions which use the UNCITRAL model law to decide, take their own view on the scope and how and in what manner they want to exercise those powers as conferred by Article 27. So that's the general position under the UNCITRAL model law, which is that, for instance, provides the law, in basis of the international arbitration law in jurisdictions such as Hong Kong, Australia, Germany, and so on. But yes, so there are other examples as well from other jurisdictions around the world, and I think what they do is broadly underline and support a pro-arbitration stance, because what the court should be doing is supporting and assisting parties in making sure their arbitrations can proceed swiftly and effectively.
Thank you for that. So have we pretty much exhausted these important issues?
I don't think we'll ever get to exhausting it, Chucky, but I think we've covered the main points. Okay. We've touched on, I think, the important thing is really looking again, and this is the great thing when we've got a podcast that's been going for as many episodes as we've managed to keep up so far. But as the law has developed in the US and indeed in the UK, what we're seeing is the developments and changes, and really how points which we've looked at before perhaps now can be looked at slightly differently. And I'm sure we'll be revisiting these issues again in future podcasts to come. Agreed,
and I look forward to it.
Well, once again, Chucky, it's been great chatting with you and sharing your perspectives from across the pond, and I look forward to our next catch-up.
Same here.